Hello again, everyone. This is Louis Setti speaking as the Blue Ridge Reporter about a story that appeared today in the Washington Times under the byline of one of its reporters, Jerry Sieper, about the prosecution of a former United States Senator from Alaska, Ted Stevens. That prosecution had resulted in a conviction in October of 2008. At that time, Senator Stevens had been the longest-serving Republican senator in the Senate's history. Just a few days after that conviction, Senator Stevens lost a close re-election bid, and then in 2010, he died in a plane crash while other events regarding that conviction were unfolding. And what happened was an FBI agent had testified, had told the court after the trial, after the conviction was obtained by prosecutors from the U.S. Attorney's Office in Alaska, that the prosecutor had withheld exculpatory evidence that would have, by its exculpatory nature, helped the Stevens defense quite considerably, in fact, and that there had been a pattern of sorts in the prosecutor's office about withholding that evidence. As a result, there was a special legal counsel appointed to investigate the matter. Ultimately, the charges against Senator Stevens were dismissed. Therefore, his conviction was rendered null and void. And today, or recently, a 500-page report was released by the special counsel, a scathing, blistering report of repetitive and numerous errors by the U.S. Attorney's Office, failures to turn over exculpatory evidence. Now, as a former state prosecuting attorney, and as a former defense attorney in state and federal courts, exculpatory evidence is critical evidence. And the purpose of the prosecution turning such evidence over to the defense prior to the trial with enough notice so that the defense can develop a means of using that evidence or even investigating further to follow that thread perhaps and find more exculpatory evidence. The purpose of all this is to make sure the trials are a real effort to find the truth of the matter, as opposed to being a combat between legal titans who are so fixed in the competition against each other that they might hedge and hold back exculpatory evidence that can result in a person being found guilty when they ought to be found not guilty. It is a serious offense, if intentional, to hold back exculpatory evidence. It is a serious professional failing, if simply negligent, to hold back exculpatory evidence. And any defense attorney would feel outraged by being on the wrong side of such a withholding of evidence and have his client prosecuted and convicted when the exculpatory evidence might otherwise have changed that verdict. The U.S. Attorney's Office, Department of Justice, is conducting its own investigation about what went wrong. And there was a statement in the story that to people who are not attorneys might appear to be significant. And I would venture to say, as an editorial comment, that it's not significant. It doesn't say much. And I'll tell you what that statement is. It says, since dismissal in 2009, that's dismissal of the conviction against Senator Stevens, the department, that's the Department of Justice, has instituted sweeping training curriculum for all federal prosecutors and made annual discovery training mandatory. And further, that the U.S. Attorney's, the Department of Justice has taken unprecedented steps to ensure that prosecutors and their staff members don't mishandle exculpatory evidence. To me, without sounding too judgmental about this, that seems almost a ridiculous statement. Let's give you some context about this. By the time a lawyer becomes a U.S. attorney, he spent many years developing a very significant legal reputation. He knows the significance of exculpatory evidence as much as you and I know about the significance of stopping at a stop sign. Anybody who is an assistant U.S. attorney, and they may be fairly young and not very long out of law school, are nonetheless among the top graduates of law school, some of the very best law students. It's very competitive to get into U.S. attorneys' offices. And they surely know, simply by reading the law books in law school, what exculpatory evidence is and why it's so critical. Why in the world would you need to institute a sweeping training curriculum for all federal prosecutors? That's a public relations statement, in my editorial opinion. Now, the statement includes the word discovery. Discovery is a term in the criminal procedures whereby the defense will discover from the prosecution the evidence it has. Now, there are certain limitations regarding the timing of that, but that discovery would include exculpatory evidence. So, in any event, I hope that gives you some context about this. Let me say that having worked on both sides of the courtroom, when I was a prosecuting attorney, I thought I was some prosecutor. But then when I got to be a defense attorney, I realized, hey, you know, the prosecutor's got all the evidence. I don't have anything. So there are different perspectives, of course, from both sides of the courtroom, from each side of the courtroom. But I will tell you this. A good defense attorney is law enforcement's best friend. There is no better way to build public confidence in the validity of convictions than for each trial to be properly and vigorously challenged by the defense. Then, when a verdict of guilty is rendered and someone faces a significant criminal penalty, including perhaps incarceration, there is a possibility that there will be absolute confidence in the results of that verdict if the prosecution has been challenged by a properly aggressive and unyielding defense attorney. Contrariwise, if the defense attorneys are nothing more than sparring partners that throw a few punches but don't really take it seriously, then all prosecutions, the validity of them and the results of them would be viewed dubiously by the public, and rightly so. So it is a sense of combat in the courtroom. There is definitely the competition, and I can tell you attorneys can lose sight of that in the midst of the battle, which brings in the third player, the judge. But in any event, it all works together if properly executed, and exculpatory evidence is critical to making the system work. This is Louis Setti speaking as the Blue Ridge Reporter.